Yes. Hello, my beautiful friends. What an amazing day it is. I'm so grateful you're joining us. We've got a boatload of information to parse through today, and it is some good stuff because there was a legal doozy happening out there in New York and a bunch of filings that we've got pulled up. Now that the tubes have connected themselves, let me give you a quick preview on what we're unpacking today because there is a lot out there. And we're going to start off with what's happening in New York because Trump's sentencing is still on. We were reading through Trump's notice yesterday to the courts saying you cannot sentence him because that's what immunity is. Immunity means you don't get to be penalized from the process. You're immune to the process. You're not immune only to the outcome. What's up, locals? You're immune to the process. And so what we saw from Trump's team yesterday was a notice to Merchan. You cannot sentence us. But what we've got today is Alvin Bragg's opposition. So he came back out and said, yes, you can. And right after he submitted this is from Bragg's office, Merchan came back out and issued his order. He barely read it. This thing was fresh out of the oven, and he already came back down and said the sentencing is going to be on. So then Trump's team came out and filed a notice of appeal, petition to the higher court, and submitted this. You see, it's a 502-pager. And there's some good stuff in here that we'll parse through. We're not going to be able to read all 502 pages as much as I'd like to. But a lot of it's transcripts from prior proceedings and more. But what you'll see is Trump filed the appeal. They had oral arguments today, and then we got an order from the Court of Appeals. All that happened in like 12 hours. And what you can see here is that the sentencing as it stands is now on. It is happening this Friday on the 10th. And so, of course, we're going to be here and we're going to be live streaming all day just to make sure that we're covering that for all future people of this universe. So we got that coming up. We'll go through and zoom in on each of those. So we got a little bit of a bad news, good news day, good news, bad news day. We'll start with the bad news. Trump's sentencing is still on. Good news, Jack Smith lost again. Man, this guy just is not tired of losing, apparently. He just keeps losing. So, of course, Trump's case has already been dismissed. The Florida classified documents case that was prompted by Joe Biden, Merrick Garland, and then they raided his house. Well, Jack Smith left the case because he's not a real boy. Judge Cannon said, you're illegitimately on this case. You're illegally appointed, and you've been stealing a bunch of money. Since you're not a real boy, you can't have a real allowance either. And Jack Smith just said, well, whatever. Kept prosecuting it. Now they're off the case, but now we've got Walt Nauta and Carlos, the two co-defendants, who were joined by Trump, and they submitted an emergency motion to her in Florida, and they asked her, do not release the special counsel report. And she came back down immediately. Okay, so this also happened very quickly today. Stanley Woodward, you remember his name. We talked about him yesterday. He's going to go be an advisor to the president, and that's cool. But he submitted this on behalf of Walt Nauta. And then Judge Cannon came back out and issued an order. So then Jack Smith's team responded to this, James Pierce, along with Jack Smith, probably one of their final filings as this gets wrapped up. And they're saying that the Jack Smith report that is going to be hundreds of pages of smear garbage that they're going to try to hamper Trump with right during the middle of this transition and as this new administration is going to enter us into the golden age. What we got from Jack Smith and the lefties is an attempt to try to destroy that. So Jack Smith responded. We'll look at it. And then Judge Cannon issued the order. And she says, there's going to be a stay. Okay, you were temporarily enjoined from releasing your report. And then we've got a lot of reaction to that. So Trump heard about this live today. We've got other people speculating. What do the appellate panels look like? We've got different people like Liz Cheney who are coming out and crying about all this and more. And so Jack Smith is failing again. We've got a bunch of documents to read through and to get through today. And we're very excited to do that here with you. Of course, we have other precautions to take before we get into the business on the day. And you know what those precautions are and how we can be protected from it all? That's right. Our friends at the Wellness Company, because as we know, Trump just won the election. We're waiting for the inauguration to happen. And now they're saying that there's bird flu popping up all over the place, and probably saw that story about that strange virus over there in China. And a lot of things are happening right now in these final days. We had other situations where CDC is confirming the bird flu. A lot of people upset with RFK Jr. and his nomination to be head of Health and Human Services. So the question is this some sort of a mental tactic, or is this a real thing? Well, we want to be prepared, and we've already talked about it because we've talked about Dr. Peter McCullough. He's been here warning about bird flu, talking about a lot of these things for a long time, and that's why now we've got a contagion emergency kit from our friends at the Wellness Company. His medical board approved solution has 5 critical life-saving medications inside. It's got Tamiflu, nebulizers, all sorts of stuff that every household should have in case you need these medications. And so you can get yours. Go on over to the link down below. Fill out the digital intake form and your kit is going to arrive in 1 to 2 weeks. Going to be very easy for you to do that. Don't wait until it's too late. Get your kit. Go to twc.health/Robert. Use code Robert. You're going to save $32 and you're going to get free shipping when you check out, courtesy of our friends at the Wellness Company. It's for U.S. residents only. And my friends, now you can get prepared. Thanks to the Wellness Company for sponsoring today's episodes. And thank you for getting prepared in case you need that stuff. All right. And so now, without any further ado, let's get into it on the day because we've got a lot of docs to read. All right. So starting off, Trump's sentencing is still on, scheduled for Friday, the 10th. We've also got responses now working their way through the courts in other arenas. We know that Trump submitted an appeal to stop it, was rejected in New York. And so now the question is his team going to file some sort of emergency petition with the Supreme Court, or what's coming next? But we know it's something. But here's what happened today. People of the state of New York versus Donald Trump. This is the Judge Merchan case, the false business records case that brought out Stormy Daniels and convicted perjurer Michael Cohen. And this is Alvin Bragg's opposition. So yesterday on the show, we read through Trump's defense motion saying, Judge Merchan, you cannot sentence us because of presidential immunity. Presidential immunity means you're immune from the process, not just from the outcome, but you cannot go through the process. Trump has a very strong basis for that. One basis being the United States Supreme Court, which said that he does have immunity, sent it back down to Judge Chutkan, and she was properly contemplating how to process that moving forward. But Judge Merchan is ignoring the immunity conversation and accepting his own determination that there was no official acts that were entitled to any immunity at all. So what we see right now on the screen is Alvin Bragg's response. Trump said, you cannot sentence me. Alvin Bragg responded and said, yes, I can. Now, I'll just show you the quick highlights of these documents because we have a lot to get to. But here's what Bragg said. He says, the court should deny Trump's request to stop the sentencing hearing, saying, as is clear, pre-trial immunity could foreclose an unnecessary trial, but we've already had a trial, okay? The case is already done and closed. And you've already explained, Your Honor, that you're not going to even sentence him to jail. You're going to give him a total discharge, so no fines, no jail, no probation, no penalties at all, other than he'll be convicted now, and he'll be a convicted felon, which by itself imposes certain penalties. So he says it's an unconditional discharge. So there's no risk of an extended proceeding or any of those things, nor should the court grant a stay and stop the sentencing because this weighs in favor of the people. We want prompt prosecution. We want finality of criminal proceedings, the standard stuff that you'd expect from a prosecutor. And the current schedule is entirely a function of Trump. We're sorry that we have to sentence him right before his inauguration, but we have to because he asked for additional time back before the election. And that's right. Trump did say you should postpone this until after the election. And now they're saying, you want to postpone it again? Well, we did postpone it. We got what you wanted there, Trump. So now eat the sentencing. They say Trump has already advised the court he's going to appeal these things. And we're going to look at that because he's done that. And so Bragg goes back through the 16 pages and says there's no real immunity here. Now we can fast forward because the judge already ruled on this. Here's what Merchan said today. Actually, this was late yesterday, January 6th, and we were wondering if Merchan was going to get it in time because Trump's defense team in their filing to Merchan where they said you have no choice but to stay this. You are prohibited by the federal Constitution via the U.S. Supreme Court from doing that. And they demanded that he get a response to them back by 2 p.m. It looks like he abided by the incoming Attorney General, Deputy AG. Now, this is what Juan said in response. Very short filing. He says, all right, look, and we read this yesterday, by the affirmation of Todd Blanche and the accompanying memoranda of law dated January 5th, Trump gave notice. Trump, in other words, Merchan saying, oh, you're noticing me? Like it's automatically stayed? No, I'm the judge. It's not automatically stayed. Specifically, Trump notified this court that he's going to initiate appellate proceedings on January 6th to challenge our orders. Trump also claims that commencement of these appellate proceedings immediately results in an automatic stay of these proceedings. And we're going to see what they said to the appellate court there in New York. Now, in the alternative, they say, if you don't automatically stay this, then we ask you to do it by your choice, by discretion. So by memo stated and dated on January 6th, Alvin Bragg, the motion that we just looked at, they oppose an automatic stay. They say, no, Trump can appeal if he wants to, but it doesn't automatically stay this case, meaning the sentencing stays on. In support, they submit that the equities, if you just balance what the people need, what the people want versus Trump, what Trump wants and what Trump needs, they tip in the people's favor. And Trump is not going to be harmed if we sentence him. They also say that Trump is not going to win on any appeals. And they know that probably because, of course, they're in New York. Now, this court has considered Trump's arguments in support of his motion and finds that they are, for the most part, which is like a joke, a repetition of the arguments he's raised numerous times in the past. Okay, well, what about the other part? Because you're not going to get to it in these like 4 sentences that are left. So what about the other things that are not the same? Whatever. Yeah, for the most part, whatever. What time is it? Okay, here. For the most part, it's good. Including in criminal law, the motion to vacate his conviction and another Clayton motion, which is another motion to dismiss. He's like, you just keep filing this crap. I don't even care. I'm not even reading it. Denied. So further, this court finds that the authorities that are relied upon here are also factually distinguishable. So the cases that you're citing that you say I have to follow are not even important. No, they don't even matter here. So therefore, Trump, your motion for a stay of the upcoming sentencing scheduled for this Friday on January 10th is denied. So your sentencing will be on. And now, of course, the judge has already said that he's not going to sentence him to jail or probation or fines or any of that stuff. But that's just his word. And nobody trusts this guy because he's a corrupt hack who lies about his daughter and gags everybody who want to talk about it. He says, as he wraps this up, nothing in this decision shall preclude Trump for appealing. If he wants to appeal, he can go ahead and appeal. That's fine. This is the decision and order of the court. And so Trump can appear by Zoom if he wants to, or he can walk right in there and look at Juan's disgusting face right in his eyes. And we'll see what the president does or what his team decides to do. But one thing they did do is they filed a notice of a petition. They filed an appeal up to the appellate division in New York. And this came out 9:30 this morning, fresh out of the oven. They're moving fast on this. They've already had oral arguments and we already have a decision. But here's what Trump's people are saying to the corrupt New York court system. They say, all right, listen, we are now appealing this. Here they are denials by the lower court judge, Merchan, acting judge, of Trump's official acts immunity. We have absolute immunity of a sitting president and a transitioning president under the Supreme Court precedent and under federal law and under New York law. And so we're appealing this to you. Signed by Todd Blanche, incoming Deputy Attorney General, and the Assistant Deputy AG, Emil Bove. Copied to Matthew Biden's prosecutor, Matthew Colangelo. Joe Biden's prosecutor, Matthew Colangelo. Here's what they say. All right, listen, Court of Appeals. Trump is now appealing this to redress the serious and continuing infringement on his presidential immunity and criminal process as he transitions in as the 47th president. In this petition, Trump seeks review of two closely related, interlocking, erroneous decisions by Judge Merchan denying Trump's claims of immunity. One, on December 16th, he said Trump doesn't have any presidential immunity based on the evidence that was presented at trial that they'll get into. And then two, the recent decision just days ago where he denied Trump's post-trial motion that said he also doesn't have immunity now as he's transitioning into the presidency. These are errors. They are violating Trump's fundamental due process rights, and they're resting on the testimony of a disbarred, disgraced, serial liar called Michael Cohen, convicted perjurer. Saying Judge Merchan's terrible and erroneous decisions threaten the institution of the presidency. They run squarely against the established precedent, disallowing any criminal process against a president-elect, and they are violating the prohibition against the use of presidential official acts in a criminal prosecution. And so under Trump, the Supreme Court case, under the Supremacy Clause, under the Constitution and other law, including the New York Constitution, Justice Merchan is without authority under the law to proceed to sentencing, while Trump exercises his constitutional rights to appeal and to vindicate the erroneous jury verdict. And so everything here must be dismissed without delay right now. They tell us Trump is going to be the 47th president of the United States. Merchan is the acting justice of the Supreme Court. Alvin Bragg, we know, is Alvin Bragg. And a lot has happened here. In fact, in February, the U.S. Supreme Court accepted the Trump immunity case. Within a week of that, Trump moved to exclude, back at the lower court, all of Trump's official acts at trial, saying you cannot talk about those. That is immune. Judge Merchan didn't care. Trump specifically challenged several pieces of evidence that were shielded by Trump's immunity, including his ex posts where he communicated to the American people through that. Judge Merchan denied everything. He cited a bunch of garbage. He declined to consider whether immunity precludes that evidence, right? And he wrote that. They're citing that for us. Then on April 10th, Trump filed a petition up to the higher court. They said, you know, the lower court judge is terrible. And that came back down. They denied the petition. The court said, you may raise your issues of immunity on a direct appeal. That's what we're doing right now. So we're doing what you told us to do. On April 15th, then, the first day of jury selection, Alvin Bragg made an offer of proof of official acts of President Trump while he was in office. Trump again objected, said, I'm immune. I'm the president. I'm allowed to do those things. He submitted his objections to the judge, which included objections to statements made from his ex account and documentary evidence of his presidential actions. Then on April 19th, Merchan said that Trump would have to wait until trial. You can't raise those objections now. Raise those at trial. That runs against the requirement of Trump that those get resolved pre-trial. The Supreme Court said you have to review all of that before the trial starts so that we can rectify it before the jury gets impaneled. Thus, Justice Merchan violated the doctrine right there. Then we had the trial. Throughout the course of the trial, Trump renewed his objections. I object, I object, I object. Trump elicited objections, and the trial brought out lengthy testimony about Trump's official acts. For example, Alvin Bragg got testimony from former White House Communications Director Hope Hicks. Hicks joined Trump's administration in 2017, and her official duties were helping with Trump's agenda. She came in and testified. She worked in close proximity to Trump. Her duties included coordinating communications directly with the president. At trial, they asked her specifically about this. Her official communications with Trump about the Wall Street Journal article that was brought into evidence by Alvin Bragg. She says, I spoke with Trump about how to respond and about a team response. All of that was Trump communicating with his employee, a government person from the White House. Hicks also testified about her communications with Trump about a New York Times article that was referencing Michael Cohen's payments. She said, I did speak to Mr. Trump. I was the communications director. So this was a major interview. Yeah, we just spoke about the news coverage of the interview and how it was playing out. They also brought in another official witness who worked with Trump called Madeleine Westerhout, special assistant and executive assistant to the president. She came in, talked about details from the White House, including invasive testimony about all of this, work habits in the Oval Office, and more. All of it official conduct that they brought in. During trial, they also talked about his X account, Twitter at the time. They offered evidence about his official actions. During closing arguments, they repeatedly talked about official acts immunity from Hicks and others. Then on May 30th, the trial concluded. The United States Supreme Court, on July 1st, issued its decision in Trump versus United States. One day after the trial concluded, Supreme Court comes back out and says, oh yeah, I got immunity. The court held that the president has absolute immunity for his core constitutional powers. These are the three buckets we talk about. At least presumptive immunity for other things that are within his outer perimeter. So absolute, presumptive, and then the third category is no immunity. The court held that the doctrine of immunity prevents the evidentiary use of official acts against a president. They just did that multiple times. We gave the examples. After the decision, Trump went back and gave Merchan the legal backhand and said, hello, you have to set this aside. Then we set a briefing schedule and more. Trump then filed a detailed motion to vacate the jury verdict, says you relied on illegal evidence and you can't use it. Merchan then denied Trump's motion. Now his order was wrong. He conceded that many of Trump's claims were properly preserved. Yeah, all of those objections were there. He wrongly found that other claims were unpreserved, even though because we made objections 170 times during this. And then Merchan disregarded the Supreme Court. They had a strict instruction back to him. All right, listen, Judge, questions about whether the president may be held liable for actions must be addressed at the outset of a proceeding, not at the end. They focused improperly on objections and waivable this, that, and the other. He erroneously held this judge that none of the evidence about the White House Hope Hicks testimony was covered. No, that's not immune. He gave no weight to her. She's an official role. She had an official role at the White House. He didn't even care. He declined to follow the Supreme Court. They told him it forbids testimony from his advisors. You don't get to probe the official act with highly intrusive inquiries and go into Trump's motive. That makes you the president. You don't get to substitute your judgment for the president and say, well, maybe he shouldn't have had that conversation with his close advisor or whatever. That's their branch, not yours. In particular, these communications involved public concern to the American people. And Merchan committed another error when he allowed Madeleine Westerhout, her testimony, to come in. She was a close advisor. They were asking her about sensitive internal discussions here. And Merchan also erroneously found that none of Trump's postings on X were official acts, which is ridiculous. In so finding, he said, well, some of those tweets don't fit the mold. They're entirely personal, and there's no policy concern or public interest. Yeah, this is despite the fact that we know that Merchan hates Trump's tweets and X postings because his daughter was telling her podcast co-host about that, saying, my dad doesn't like when he tweets. And it's on recording. We have it. Merchan declined to follow the clear instruction in Trump. And most of his communications are likely to be immune or at least within the outer perimeter of his official responsibilities and therefore presumptively immune. Public communications through White House social media accounts and employees, those are clearly presidential acts. Here, Trump possessed actual authority to speak on behalf of the executive branch, and he was addressing concerns of the American people. Now, Merchan reasoning that Trump's decision were permitted, saying that his strict instruction of these things, if Trump were not allowed to post on X, then it would chill the president's willingness to communicate with the public if now all of those things are suddenly not official. And you could be prosecuted, and that can be used as evidence against you for promoting policy ideas. Merchan incorrectly found that the evidence of Trump's statements on forums were not official, and so they did everything they could and made a number of errors in saying that none of this was official. He also wrongfully found that the admission of official acts was harmless. Well, maybe some of it was official, but it was harmless. He found evidence presented to the grand jury did not consist of official acts. He said, no, they're just personal conversations. He relied on his previous findings. He violated the doctrine of presidential immunity. He admitted extensive testimony about Trump's conversations with his cabinet. At trial, Alvin Bragg presented a 2018 text message from convicted perjurer Michael Cohen, who was working for Trump, indicating that Trump had approved Cohen addressing an FEC complaint. Okay, that's Trump's official actions with his attorney. Contrary to Justice Mercan's erroneous decision to admit those statements, he said they can come in even though they're within the outer perimeter, at least arguably the outer perimeter of his official responsibilities. Cohen also testified that Trump told him that the FEC inquiry would be taken care of by Attorney General Jeff Sessions. And even if that is a conversation that happened, that's a conversation about official business. All of it got admitted. They say, look, here, even if this conversation had happened, which we don't concede, even if you believe convicted perjurer Cohen about that, his testimony is explaining presidential action. And you allowed that to come in. So the judge abused his discretion. Now, during the trial, perjurer Cohen also sought to justify his perjury before Congress and Trump's public statements about the special counsel investigations as well. Now, moreover, power of the presidency includes the authority to communicate to the people. That's kind of why you're there. And Bragg also elicited testimony from Cohen about the power of the presidency, about how he would back channel things. And so then Trump got reelected. All right. The jury came in, they found Trump guilty, and all of these things should be reversed. So then what happened next? All right. They're giving us a timeline. On November 5th, Trump got reelected, landslide. Once Trump became the president-elect, we've got 75 days of a crucial time. A sitting president is shielded, and Trump, as a transitioning president who's coming in, is also shielded. Alvin Bragg even admits, once Trump assumes office on the 20th, the underlying criminal case against him is stopped. Justice Story talked about this. Sitting president immunity protects Trump now. And this goes all the way back through multiple cases. And so once a president assumes office, any criminal cases against him must be dismissed. And sitting president immunity also shields the president-elect, because that is now an official position. The federal special counsel's office even agrees with us. They agreed with the reality of that. Jack Smith dismissed his January 6th case and lost his Florida classified documents case. In fact, the Presidential Transition Act, Congress emphasized the continuity and identity between the transitioning president and the current president. Lots of law there. The presidential nature is also recognized by President Kennedy and many others. The structure of the Constitution and the separation of powers means that it's like one person's handing the baton off to another. So Trump has become the incoming president, the elect. Any criminal sentence or even the distraction of ongoing criminal proceedings, including these appeals, including this sentence, threatens to disrupt the burdensome task of the presidential transition. Even the federal DOJ agrees. Now, the president-elect must immediately begin addressing all of the important things. Their complete engagement and undivided attention must be focused on their job. There's also public stigma, which is really what they care about most. They need Trump to be a convicted felon, and this is their last gasp to get it done. Indeed, the severity of the burden imposed upon the president is happening now, and once again, the same reasoning applies now. We don't want to stigmatize the incoming president with the burden of criminal prosecution. And during the transitional period, he must communicate with world leaders, select key personnel, and do many things. Making the president focus on this undermines the institution of the presidency. And we don't want our own country to do that to itself. Third, the mental and physical burdens are also taxing. Defending criminal litigation here, especially at sentencing, is extremely taxing and burdensome. These demands of time and energy drain and disrupt the presidential transition. Sitting president immunity requires you drop this. Permitting prosecutors to leave an indictment against a sitting president pending during his term in office would play Russian roulette with America's vital interest and its national security. And so, given the realities of modern politics and mass media and the delicacy of political relationships around the world, there would be a Russian roulette aspect to the course of indicting the president but postponing trial. And that came from an OLC memo. That is from the Office of Legal Counsel, even before Trump was anywhere on the political scene. Trump already argued this should be dismissed. On January 3rd, Merchan entered an order erroneously denying the dismissal. He acknowledged that a sitting president is immune. That's why they have to cram this in on the 10th. But he erroneously said that it doesn't apply now, but it does. His entire analysis is erroneous, says Trump. It relies on case-specific application of certain factors, but the analysis is obviously wrong and an abuse of discretion. He only asks whether those three factors would prevent a significant obstacle, but that's not what the Supreme Court said. His analysis is wrong because it directly contradicts the reasoning of the very memo that he is citing. The memo says that the presidential immunity doctrine does not depend and must not depend on a case-by-case analysis. We don't do that. It says it's categorical, okay? If you're the president or incoming president, you are not subject to a case-by-case basis of balancing whether some hack prosecutor like Bragg and Colangelo can bring a case. That's not how this works. That's what the Supremacy Clause is. This case-by-case basis is wrong as a matter of law. Even the Office of Legal Counsel and the insane DOJ agrees. And so now we are petitioning for a reversal of Merchan's orders. The Constitution and the framers want this system in place. That's why we have immunity and these concepts. And so, citing a lot of law, they say Bragg unconstitutionally elicited testimony from Hope Hicks, said that they spoke every day. You can't do that. You can't bring in testimony from advisors. It's highly intrusive. You can't judge what the president is doing. That makes the prosecutor and the judiciary subject to an interference in the executive branch. It's a separation of powers problem. Trump's internal deliberations about the White House response are absolutely immune. He was supervising somebody who is wielding executive power on his behalf. That's Article 2, absolutely immune conduct. And Trump was also communicating with the American people, absolutely part of the presidential role, using X to do it. And Judge Merchan's failure to appreciate the seriousness of this doesn't mean that the evidence comes in. Because Trump's statements were plainly within the outer perimeter of his authority, it should have never been admitted. Merchan completely ignored the critical issue the Supreme Court told him to review. And even more important, they failed to appreciate what they've done. And what this has done is created a dangerousness to the entire institution of the presidency. And so the appeal continues on, and we'll just hit the highlights of this because the order coming back down was quite short. The use of official acts evidence requires dismissal. You brought in illegal evidence, and the verdict needs to be dismissed. Trump's immunity is mandated because he is now president-elect, and Merchan is causing irreparable injury to Trump and to the entire country with his lawfare lunacy. By allowing these criminal proceedings to continue in violation of Trump's constitutional rights to presidential immunity, this is committing irreparable harm upon President Trump. And so therefore, Trump respectfully requests that this court grant judgment in his favor as follows. Find that the continued criminal proceeding is unconstitutional and unlawful. Direct the jury and direct the case and the jury verdict in the underlying case to be vacated and immediately dismissed, and any other items as deemed appropriate and proper, signed by Blanche Law. Now that filing is a good one. It's 502 pages. You can see a bunch of exhibits from all of the other filings, his affirmation, and note his other motions. We objected. This is what we've done. And it goes on for 500 pages. So you can see 9:30 in the morning. Now, the judges in New York want Trump sentenced so badly that they threw everything off their desks today and they said, let's have a hearing right now because they need him to be a, quote, convicted felon according to garbage New York law. So they did that. There was an oral argument that took place today. Adam Klasfeld was there inside reporting, and he said an appellate hearing is about to begin in New York over Trump's efforts to overturn his guilty verdict and block the upcoming sentencing on Friday. Here's what happened. Judge came out. Do you have any support for the notion that presidential immunity extends to presidents-elect? Well, he's like not the president yet, you know. Todd Blanche says, well, Your Honor, no. There is no case law for this because this has never happened before. We've never had hack losers like Alvin Bragg and Matthew Colangelo do anything like this, or disgusting judges like Judge Merchan enable it to this extent before. So no, I don't have any case law. Sorry, it's never happened before in American history. Thanks. Judge says, oh, well, you don't have any case law then, so I guess you're going to lose. So he continues to report. He tells us, Stephen Wu for Alvin Bragg's office comes up. Your Honor, I mean, the theory of president-elect immunity is inconsistent with the fact that there is one president at a time. He's like, wow. Everybody in the DA's box was like, oh, brilliant. One president at a time. Such a great argument. You're so smart. Thank you, Stephen Wu. What a genius. And the judge is like, yeah, that's a great point. That's really smart. It's true. So then the judge says, Stephen Wu says, Your Honor, there's also an omnibus motion for Bragg's office because Alvin Bragg can't argue anything. Did not raise a general claim of immunity, only claiming that certain evidence was related to official acts. He says, so this is a case where criminal charges and convictions are related to unofficial acts. So there was no official acts business, Your Honor, at the Court of Appeals. And so nothing was wrong. He says, the appellate judge, Your Honor, and you can trust Judge Merchan because they flow from his understanding of the constitutional landscape after Trump gets back into the White House. Oh, gosh. Trust Judge Merchan? You mean the judge that made 2 donations to Joe Biden? I think 3 of them, actually. To Joe Biden and anti-Trump organizations? That judge? The same judge who is so upset about Trump's tweets that he rants and raves like a maniac so loudly that his daughter hears it and is so concerned for him that she brings it up in a podcast. Like even my dad hates it. Your dad's a judge, so maybe you should watch that. But in addition to that, the judge's daughter works for Democrats and helped them campaign and raise millions of dollars. Then the judge, because he's so guilty, gagged Trump from talking about it because he knows if Trump talked about it, he'd be busted big time. You only gag people when it's true. We all lived through that back during COVID. We all got censored back when it was all true. So Klasfeld says that the reporting continues. Over the appellate hearing, a fault line has emerged over Judge Merchan indicating that he was leaning towards an unconditional discharge without jail, fine, or probation. Todd Blanche, Trump's defense team, Your Honor, I don't care what he said. It's the judge's non-binding intention. If he's not going to fine him or jail him, he's still going to convict him and sentence him. And there will be penalties associated with that. For example, will Trump be able to vote in 2022 if they do this? Alvin Bragg's office says, oh, Your Honor, that's ridiculous. You can trust Merchan's remarks, okay? He understands what's happening and he's going to do what the Constitution abides. Trump's attorney, Todd Blanche, comes back and says, Your Honor, he says, there was a skeptical reception in the appeals court today, and we got the judge's decision, and here it is. Court of Appeals heard oral arguments, read through Trump's entire motion, got the useless counter arguments from Alvin Bragg's Stephen Wu, who's like, Your Honor, there's one president at a time. Great job, Steve. And now they say, it was brilliant, amazing arguments. Trump, you lose. You're getting sentenced on Friday, so just sit there and take it. We don't care that you're the president-elect, the incoming president. We don't care that the whole country vetoed our lawfare and reelected him. We're such sore losers and big whiny babies that we're going to do everything we can to get that label on you, because that's all they care about. They're label people. They have no meaning or purpose in their lives other than their labels. They think if they get the right label, that will make them a great person. But that is not how that works. So they're working hard. You can see this was submitted by Trump, the petition. This is the order coming back down saying this application by Trump for an expedited resolution. This is the cover sheet. Here's the disposition. After consideration of the papers submitted and the extensive oral argument that all happened today, Trump's application for an interim stay is denied. And so Trump, as it stands right now, the New York judges colluded to insurrect a president who is transitioning into power, interfering with the peaceful transition, trying to sentence him using the courts to exact punishment and retribution on a duly elected official who was reelected in spite of all of this. So the judge who signed this is Ellen something or other. Ellen Germs, probably Germer, one of the terrible, whatever. So some judge signed that from New York, and the sentencing will be here happening on Friday as ordered, unless Trump's people submit something to the United States Supreme Court and ask them to step in, or just tell New York to shove it and don't show up. Now, I think that might actually make things a little bit more politically volatile and worse, because then they would issue a warrant, and I think that would actually serve them and feed them. But Trump and his legal team are probably preparing something to the Supreme Court right now, if I had to guess. And we're going to be here to see what it is when it drops. Thank you for subscribing and joining as we do. All right, so that was the update from Merchan. That's the bad news. Got that out of the way. Now let's talk about some of the more fun stuff here and another major victory. Jack Smith, the illegitimate so-called prosecutor who had his case dismissed in Florida, loses again. Man, this guy must be tired of losing because there is so much losing happening. But when you're a loser, maybe you start to enjoy it. We're going to go through several things today, including Judge Cannon's brilliant order that looks like this, where she is delaying temporarily the release of Jack Smith's disgusting book report. Now that he's not going to get any convictions because the January 6th case was voluntarily dismissed by him since Trump is coming into the presidency again, and the Florida classified documents case, which was dismissed because he's illegitimate, he was going to try to salvage his reputation and to deliver a big, disgusting dossier that he could just drop on everybody's desks right around the inauguration that would show that Trump's a bad person, and the media could lap it up for a week or two and sour what is going to be America's greatest golden age in modern history. But now he's going to be delayed from doing that. And the reason being is because Trump submitted this to Judge Cannon, Trump's emergency motion to preclude the government from releasing illegitimate Jack's special counsel's report. Trump did not write this per se, but he's joining it in spirit. And the person who did draft this, because Trump's case has already been dismissed here. Remember, we're in the Southern District of Florida. Trump's case is gone because Jack Smith was illegally appointed to prosecute him. And Walt Nauta and Carlos de Oliveira were still co-defendants who still have their case moving forward against them. So here is what they are filing, and they're joined by their attorney, Stanley Woodward, who we've talked a lot about here, who's representing Walt Nauta. Now, they are writing this. Listen. Despite this court's concluding that Jack Smith is unconstitutionally appointed and funded, and despite ongoing proceedings against Walt and Carlos, which should be gone, right? If Jack is illegal, they should be gone. Special counsel Smith, in defiance of this court's ruling, is determined to have the final word by pushing forward with his, quote, final report that Merrick Garland is certainly going to release and make public immediately. Now, these two guys here, who are still defendants in this case because their case has not been dismissed yet, these defendants will suffer harm. They're going to be civilian casualties in this war between Jack Smith and Trump. And they're impermissible and contumacious. Oh, there's your $3 word of the day. All right, just write that down in your notebook. Turn to your neighbor and say contumacious. And look it up after the show. Utilization of political lawfare to include a release of an unauthorized report. The final report and the materials on which Jack Smith relies are disqualified. He's disqualified. He shouldn't have any access to any of this, okay? His email account should have had its password changed a long time ago. You don't get to touch the Dropbox account, okay? You're kicked off the server. You're done. You're not a real boy. You don't get to do this work anymore. But for some reason, he was. The DOJ just allowed him to do it. And he was still prosecuting over in the J6 jurisdiction. Making his attempt to share these materials highly improper. This court and their authority to regulate the participants and the attorneys in this matter and to preserve the authority of your orders, like Judge, if you're saying Jack Smith is illegal and illegitimate, well, he can't just do whatever he wants then. I mean, does your word mean anything? Or can he just do whatever he wants? And you say he stole, he was illegally appointed and then illegally appropriated a bunch of money, but now he's taking that money and he's just going to write and release reports. Like, are you going to sit there and take that, Judge? The court's control of the proceedings compels this court to preclude this imminent act of defiance of this court's authority by the government. Judge, you better not allow that to happen, man. And so Trump requests an immediate hearing on this motion, and we're going to establish the impropriety of this unchecked release. We're going to tell you about the prejudice of this report. And even if any version of this report is transmitted and released, I don't care if it's done, I don't care if it's in draft form, I don't care what they're doing. These defendants maintain no such release would be warranted at all, and we're at least entitled to a hearing on this. And if they want to release it, they should explain why. They request that this court enter an order stopping Jack Smith from transmitting the final report or anything else to anybody. Do not edit it. Do not access materials on which the report relies until this court resolves this. So you're frozen. You don't get to run off and publish an illegal report. The final report, Your Honor, promises to be a one-sided, slanted report, relying nearly exclusively on evidence presented to a grand jury and subject to all requisite protections. You can't just share what happens in those proceedings. These are secret proceedings, which is known to Smith only as a result of his unconstitutional appointment. He should have never been privy to that information in the first place. It's going to serve a single purpose: to convince the public that everyone Smith charged is guilty of crimes. But Nada and De Oliveira's criminal cases are not over. The appeal of this court's dismissal order by Jack Smith is still pending. Now, Jack's team is not on that. They filed that motion to withdraw, and now they've handed that off to the Southern District of Florida. The government notably continued briefing the appeal, even following the dismissal of the appeal as to Trump. And so there remains the threat of future proceedings for these two, and those proceedings will be prejudiced by the dissemination of the final report. So if you let the report go public, it's going to impact the jury pool. And these two guys have open cases. So you can't let it out. As the government knows, the continued operation of the protective order in this case will make the one-sided, impermissible final report even more unfairly prejudicial. The defendants, our clients here, are strictly precluded from refuting the report. The final report is meant to serve as a government verdict against them, and that is against all criminal norms and the Constitution. Now, critically, Trump and his co-defendants, the government never sought a stay of this court's rulings. As to the impermissibility of his appointment, the government never sought clarification of the prohibition against disclosing things. And so given the invalidity of his status under the Constitution, the invalidly appointed special counsel lacks authority to write a report, to file a report, to share information about the report, or to issue a report at all. He is illegal. The filing of a report by an unauthorized person is clearly improper, and it's going to harm the pending criminal proceedings that are now on appeal because of Jack Smith. So the prosecutor cannot be allowed to release a big smear campaign while two other individuals are still being prosecuted. Issues of disclosure and the use of materials by the government are matters that this court assumes jurisdiction over. And the filing of the final report by an illegal counsel who's unauthorized would necessarily implicate the same unresolved Fourth, Fifth, Sixth Amendment issues, attorney-client issues that Jack Smith lost when we found he had no position or authority to take a role in the government at all. And the final report would also be an abuse of constitutional and privilege powers. Sidestepping by the government to get around those things would prejudice and disparage the defense. It would taint the jury pool. It would render the defense case unreasonably difficult for us to even defend. And this court doesn't need to tolerate this crap, Your Honor. It's unconstitutional and it violates your local rules. And it certainly does not need to tolerate that prejudice when it stems directly from the unconstitutionally funded acts of an unconstitutionally appointed individual. Let's go. Whose purported authority stems directly from unlawful regulations. 3 strikes, Jack! The final report itself is also inconsistent with other constitutional, statutory, and regulatory provisions, illustrating why it cannot be released. Its release would directly infringe on Walt's and De Oliveira's rights in many ways. This court should prevent that infringement and stop Merrick Garland, the U.S. Department AG, and Jack Smith, illegal, and their officers from issuing a final report. Cannot be allowed to happen. We need this relief right now because they're going to issue a final report in the next few days. And let's go through this in finer detail. They obliterate Jack Smith. Trump's defense explains, on November 18th, Merrick Garland appointed Jack Smith. He said it's an attorney from outside the government. He's going to come in and do this. But guess what? Jack Smith was not nominated by the president. He was not confirmed by the president or the Senate at all. We filed a motion to dismiss. And guess what? The court correctly determined Jack Smith is illegal. He's not a real boy at all. They said that Smith is at least an inferior officer within the meaning of the Appointments Clause. And because there was no law authorizing Smith's appointment, he could not be funded by indefinite appropriations. And the statutes that they pointed to do not give Merrick Garland the authority to appoint somebody like Jack Smith. So you lose. Smith filed his notice of appeal, and that went up to the 11th Circuit. And then the 11th Circuit dismissed that appeal because Jack Smith said, I want to dismiss it against Trump, right? Because Trump is the president now. So the DOJ is leaving their appeal behind for Trump, but still moving forward against the other two. Now, the appeal as to Walt and to Carlos is still pending. Jack is trying to relinquish control. He handed this case off to the Southern District of Florida, as we mentioned. So he filed a motion to withdraw, got off that case. And so Jack Smith is not even on the appellate case at all now. Now, the report is coming out any minute. Despite losing in court twice and having no valid appointment, Jack Smith is determined to continue to litigate this case in the court of public opinion. In early December, news reports indicate that he's going to release a report summarizing the result of his investigation. Fox News talked about it. In response, counsel for President Trump reached out to J.P. Cooney, who is an illegitimate prosecutor along with Jack. He might be a legitimate actual prosecutor, but if you're on Jack's team, you're all illegitimate as far as I'm concerned because you all got paid from the same illegal appropriations. Counsel were told the special counsel's office would afford the meager courtesy of allowing a hard copy review of the report with comments due before 2 p.m. on January 6th, okay? So that we're going to release the report. If you want to see it, you can come read it in hard copy printed version, and you got to do it before January 6th. Counsel were not permitted to bring electronic devices into the room. It's like a skiff. The office declined to make the report available to out-of-town Florida counsel. You had to come to D.C. There's a snowstorm coming. Come look at it at my office. Counsel for De Oliveira was able to review the report on January 4th. D.C. counsel did so for NADA on Saturday the 5th. We've had limited access to review the draft report, and so somebody has seen it. A couple people have. But Garland is going to release it. The final report will go to Garland, who can then authorize the public release. There's every reason to believe that he's going to do so as quickly as possible before Trump comes in 13 days. First, someone said he's opted to release the reports from 2 other special counsels, and so why wouldn't he release Smith's? The review deadline that Jack gave to the defense attorneys reflects that public release is imminent, and less imminent now, as we'll see. So they say the time frame above shows that a relief is needed right now. Smith gave Trump and the defendants a very brief window to review that, and that expires this week. So it's fair to assume that once the window expires, the report will be released thereafter. That's within 7 days of this motion, so we have to go fast, Your Honor. What we're asking right now is absolutely necessary. We need an injunction. Stop Jack Smith from releasing the report. There was an order from you disqualifying him. And there's another local rule governing the release of info. In these principles is a Fifth Amendment right to a fair trial. This case is still very much pending against 2 other people. And Jack Smith is now trying to try this case in public after he's already been found to have been acting unlawfully and unconstitutionally, Your Honor. He's trying to take advantage of this. This would be highly prejudicial to everybody. Stopping the release of the report is necessary to protect the people here. Releasing the report is also improper because this is not Smith's case anymore. He has been disqualified by a court of law. He's now acting as a rogue actor with a personal and political vendetta against the defendants. And he's still taking money from the government. It's fraud and illegal. And he should be prosecuted. And everybody else in his office under RICO for continuing this conspiracy and absconding with government funds. Allowing him to release materials and information to the public does great harm to these 2 co-defendants and to Trump, who remain at risk of prosecution. In any other case, this court would have the authority to stop him. The same is true here. Our system simply does not allow a disqualified prosecutor to withdraw from an unlawful appeal, only then to embark on a media mudslinging tour through the issuance of a highly detailed, one-sided press release that explains what happened in the indictment and their own theory. Smith's latest tactic to release the report after being removed from the case reflects his ongoing and continuous effort to violate your order, Judge. In this instance, there have been severe implications for our 2 people. The court has previously recognized that Jack Smith is a hack. He evades court rules, selectively communicates and leaks materials to the public that are privileged. And the former special counsel's approach is anything but objective. The integrity of the future proceedings are threatened by the release of this report. And finally, you should stop this because this court has already determined, which is binding, by the way, that Jack is unconstitutional and he's got unconstitutional money. Issuing the final report makes the constitutional error of his illegal appointment even worse. Any of these reasons should justify an injunction or at least give us a hearing. The final report also threatens the future proceedings. Local rules in the Southern District of Florida say you cannot release information that is going to be a problem for imminent legal cases. Any reasonable person would expect the report would destroy these guys' chance at a fair trial. That's an understatement, they say. The final report would not just be disseminated by means of publication, it would be shared widely. Media all over the place would push it to millions of people's phones. Everybody, including talking heads, would give their reactions and their legal analysis, in quotes. I know he's not talking about us here, on events about which they in fact know only Smith's position, as portrayed by an illegal disqualified counsel. It's going to be all over the place. The mass media will become a mass microphone for Jack Smith and his political allies, left to report only the narrative that were advanced by him, even though Jack Smith shouldn't have access to any of this. The news media is already excited as heck about this. Look, they say, article, ABC News, CNN, Newsweek's on it. This report's coming out any minute now. All of this prejudice would occur in the face of additional litigation. We know that we should have an adversarial system, but our defendants should not have unwarranted prejudice brought against him. Jack Smith is trying to exploit his unconstitutional appointment. He got appointed, took a bunch of information illegally and illegitimately, used investigators and FBI agents and U.S. attorneys and other people who are, assistant U.S. attorneys and other people who are prosecuting Trump. Then he's going to gobble all of that up, cobble it together, and write a report and be able to release that. All of the innards of that report were illegally gained, ill-gotten. That's what he's trying to do here. He's going to try his case in the press. He's going to taint the jury pool. He's going to taint the legal soundness of this court's decisions. So that's even worse for you, Judge Cannon. It's like, your mom tells you don't do something and you do it. Your mom really needs to come down on you, or else her word has no force. It has no meaning. So she may not want to punish you, but she has to. Otherwise, it's meaningless. The Supreme Court has ruled that no one is to be punished for a crime without a change fairly made and fairly tried in public. And what Jack is trying to do, free of public prejudice, Jack is trying to try this case in public. Release of the report would plainly and obviously interfere with a fair trial. The report involves one-sided discussions, and it shows that it would be inflammatory. Throughout this litigation, the government has tied Nada and Walt and Carlos back over to Trump, calling him co-conspirators and more. The political motivations here cannot be overlooked. Jack Smith is rushing to release a final report right before there's a change in control of the executive branch. He and his allies, of course, are disappointed that his appointment was deemed unlawful and that Trump won, rubbing it in there. Love that sentence. That, however, is not a basis to deny due process of law, and the timing of Smith's actions reveal what they're trying to do. This court should function independently of politics. Now, political considerations certainly do not justify the release of evidence that's already not been made public. The final report contains a bunch of evidence, grand jury materials that's already prohibited from being disclosed. They're entitled to the utmost secrecy. Supreme Court has said that. You can't release that stuff. Protecting these grand jury materials protect the integrity of the jury, and they also protect our defendants' due process rights. And so even if Smith once properly had access to the materials, he is no longer permitted to access them. And so now he cannot disclose them. So he cannot write about it. Smith has proposed redacting direct quotes from the grand jury, but he's not proposed redacting information provided to the grand jury in response to a subpoena. This illustrates the need for a hearing, Your Honor. A hearing is warranted because Smith's actions and redaction proposals, they haven't invited any other further redactions. And so we need to discuss this. What should remain sealed and what should not remain sealed? And it's going to take a lot of time to have that conversation. We got to go line by line. Whatever is in his report, line by line. Nope, nope, nope. Yep, sure, nope, nope. And that's going to take a lot of time. Certainly a lot longer than 13 days. And then once Trump comes in, there is no more report. This illustrates the need for a hearing, because they are not ultimately in charge of what is redacted. That responsibility lies with Garland. This court should hold a hearing to determine what content must be blocked. There are several concrete ways where the report and its release, how it will impact the defense, Fourth Amendment, constitutional rights, and more. The imminent release of the report is a violation of many things, and so they cannot lawfully issue it. His attempt to do so is ultra-virus, out of bounds. Your Honor, your decision that Jack Smith is not a real boy is binding. Accordingly, the continued funding of Jack's activities and his office violates the Constitution. It's binding here, but they continue to spend our money. Because Smith is unconstitutionally appointed, an injunction barring the release of the report is valid. The appointment order is void. Smith is not the special counsel, and he cannot use the information in the report. And they continue. By issuing the report, he is unlawfully acting as a prosecutorial authority, and he is not. The final report's transmission to Garland and presumed release, again, is him acting unlawfully as a super prosecutor. There are significant problems with separation of power here, and he's filled with bias, prejudice, and sensationalism. They continue. They're also using illegal money. For many of the same reasons, the appropriations clause is a problem. He's paying his prosecutors to write this report. There's also every indication that they're going to issue their report during this transition. The Transition Act says you can't do that. Disruption is a constitutional issue. Release of the report will disrupt the president's ability to govern once he takes office. It's going to cause public stigma and opprobrium. And so such a burden must not be imposed, especially once a prosecutor has already been deemed unlawful by an Article III court like you. He also can't release this under his own regulations. And so, Cannon, you have the ability to issue relief here. You can grant an injunction. The All Writs Act allows you to do it. You have ancillary jurisdiction. District courts can issue injunctions, and that's what we're asking you to do here. So they tell us the impending issuance of the final report is a direct violation of what you said, Judge Cannon. He is disqualified. He's unconstitutionally appointed and funded. And disclosure of the final report would be an affront to this court. Here it is again. And it would be a contumacious action and is an improper attempt to circumvent the court's authority and to prosecute in the court of public opinion. Jack's use of these materials violates the Constitution. The protective order still applies to these defendants who are still being prosecuted. And so by placing itself above the court, Jack thinks he can just do whatever he wants. He can release materials from grand jury proceedings. He can come in, steal all of this evidence with his illegal appointment, and then just release it to the public. For those reasons, Walt and Carlos respectfully ask that this judge issue an order barring the United States and its officers, not just Jack Smith, but also Garland and the DOJ and the rest of them who haven't resigned in disgrace yet, from releasing this. And they also ask to issue an order to preclude Jack Smith from taking any action on this until we get a decision. We request a hearing. This is warranted. It's highly sensitive. The release of the final report implicates due process rights for everybody. We've conferred telephonically with the prosecutors. Now, to date, they have not consented to the relief requested by the motion. The government says it considers the meet and confer process to be ongoing. They don't want to answer. Do we object or not? However, Trump requested a reasonable opportunity for them to make a decision on this. They were stalling because they want to release the report before they responded to them. That's how scummy they are, just to be clear. However, defense counsel gave him enough time, and they're unwilling to commit to any timelines. So therefore, they said, well, we'll get back to you tomorrow. They were skeptical that the judge could do this, and they wouldn't tell us how much time before it got sent to Garland. Okay, they're like, they're going to try to stop the report. Like writing. We'll get back to you tomorrow. Tell your position tomorrow. Nope, Trump, nope. Accordingly, because of the emergency nature of this, we amend our position. If they want to amend their position, we'll tell you about it, but they're just stalling. They don't have an answer for us. And so after reviewing these, we certify this is a true emergency. We need this reviewed like now, signed by Stanley Woodward, who is going in to the White House to be a senior advisor to President Trump, which is going to be a nice position for him. We also have other people signing off on this: John Irving, Richard Clow, Larry Donald Morrell, who are there for these co-defendants. And we're not done yet on this one because there was another exhibit here. And this is what Trump sent to Jack Smith, or rather to Merrick Garland. Merrick Garland got this letter from Blanche Law saying, all right, Attorney General Garland, we're writing to the DOJ right now to demand that Jack Smith terminate all efforts towards the preparation and the release of the report. This one came in on January 6th, a very appropriate anniversary to send a letter. Now, as you know, courts in Florida and DC, two federal cases, have now dismissed both of Jack Smith's cases against the president. Rather than acknowledging, as he must, that Trump has been completely exonerated, Jack Smith now seeks to disseminate his final report to perpetuate his baseless accusations. Now, consistent with the bad faith crusade that Smith executed on behalf of you, Merrick, and the Biden-Harris administration from the moment he was appointed, we were only permitted to review the draft report of this report in person in DC, including the prohibitions on any electronic devices inside a room where the draft was. Smith's team likewise demanded, in advance of any review, that we delete prior discovery productions, preventing us from reviewing any of those underlying documents that are cited in the draft report. Wow, that is scandalous. Delete all your evidence? And then we'll show you what we put in the report so you can't corroborate what we put in our fake hack report? They are so corrupt. Delete your prior discovery productions, and then we'll show you what we wrote in ours. Sick. Nevertheless, it's clear, as has been the case with so many other actions of Smith and his staff, the draft report merely continues the politically motivated attack, and his continued preparation of the report would be both imprudent and unlawful. And so Merrick Garland, and by the way, this is written by the incoming deputy AG and his assistant deputy AG. Oh, it's a long letter. We'll hit the highlights. John Lauro, Todd Blanche, along with Emil Bove at the same law firm. Okay, so rewinding back. Here's what they say. Merrick, you cannot release this report there, buddy boy. They say, first, Smith, you lack the authority under the Constitution to issue the report. You're not validly appointed. You've stolen $20 million. The preparation and the release of this report violates the Constitution. And the draft report violates fundamental norms regarding the presumption of innocence. You're trying to impugn these two people, calling them co-conspirators. Also, preparing a report and releasing it to the public would violate the Presidential Transition Act. The act prohibits all officers from impeding the transition. And finally, the release of this report that is being prepared by this out-of-control private citizen unconstitutionally posing as a prosecutor would be nothing more than a lawless political stunt designed to politically harm President Trump and justify the huge sums of taxpayer money that Jack Smith unconstitutionally spent on his failed and dismissed cases. This is like, you're tap dancing and tiptoeing around on a criminal line here, guys. Under such circumstances, Smith's report is obviously not in the public interest, and that's because Trump won a commanding victory. And because Smith has proposed an unlawful, illegal course of action, Merrick, you must countermand his plan and remove him promptly. If Jack Smith is not removed, then the handling of his report should be deferred to Trump and his incoming attorney general, consistent with the will of the people. And you should disagree with the position set forth below. We respectfully, if you disagree, we respectfully request that before you release this report, you tell us so we can pursue an injunction so that the people are not harmed by the weaponization of the justice system against them. So, Merrick, just to be clear, in case you were unfamiliar, you know the history of this unethical election interference. You appointed him. You started it. This letter is covering some of his most recent problems. During the week of December 9th, just not long ago, we learned from members of the media that he's preparing a report. We were surprised to learn of the plan because Smith insisted that his work was not concluded, but now he's going to release a report. So that's curious. We're just noting. Then on December 11th, we contacted a supervisor to say, can we see your report? Initially, they said, yeah, you can only access a draft in DC between the 23rd and the 29th, the week of the Christmas. So like leave your family to come see it if you want to. We would only be permitted to take handwritten notes, and any comments or objections would have to be submitted in writing by the close of December 29th. Aside from all counsel living outside D.C. and planning on spending time with family, as Smith and his team knew, Smith's proposal afforded zero opportunity for Trump to assist counsel in reviewing any of this. Apparently working under a self-imposed deadline, Smith's team informed us implausibly that permitting the defense to review his unlawful draft during the first week of January would be too late to allow us to complete our work because they have to release it. Then Smith walked back those now clearly false claims and allowed us to review those the first week of January. But he still didn't allow us to use the internet or any of those other things, even though he's the office that leaks everything. We know if this report is released, it violates the law. He is already illegally appointed and appropriated. He took money and funding for an improper mission. He was never confirmed by the Senate. And so everything else that has come from that is in furtherance of a masquerade. He lacks authority to expend any funds to prepare or to issue a report. He cannot go to Kinko's to print it out. Your credit card is declined. You're an illegitimate boy. Preparation and release of a report would also be improper under the regulations. Now, his representation that he dismissed this prosecution doesn't mean he can now turn around and publish whatever the hell he wants. The plain implication is that it was concluded. It's reached its conclusion. We don't need a giant multi-page smear spread around all over the place. Public release of the report would also disrupt the transition. Congress passed the Presidential Transition Act to stop this stuff from happening, and creating and releasing a prejudicial report would create a media storm. False and unfair criticism from a hack illegal prosecutor. There are baseless attacks in there, which are an obvious effort to interfere with his confirmation hearings and more. A one-sided improper report would also violate immunity principles that Jack Smith concedes exist. There's guidance from the Office of Legal Counsel. A public report by Smith would undermine that. They previously explained that public stigma and opprobrium are valid concerns, and now Jack Smith is just going to create a bunch of it with the release of his report. In sum, Trump's defense sent this to Merrick Garland. They say, the same legal principles and logic that required Smith to dismiss his case requires the closing of this report. The collective application does not justify anything being done in the public interest. To the contrary, in fact, it does the opposite. You must countermand Smith's release of the report and stop it from coming out, saying the presumption of innocence is vital. These are bedrock principles. Even the Justice Manual prohibits prosecutors from publicly declaring guilt or innocence prior to a jury verdict, and that's what you're trying to do here. The draft report violates every one of these requirements. Despite Smith's decision to dismiss his cases and his complete failure to obtain a jury determination of guilt, his draft report comes out and says they all committed crimes. For example, Volume 1 of the draft report falsely asserts without any jury determination at all that President Trump and others engaged in an unprecedented criminal effort and was the head of criminal conspiracies in his dumb report and harbored a, quote, criminal design, blah, blah, blah. These false allegations have never been proven. Volume 2, without any verdict as well, says Trump violated multiple federal criminal laws. He engaged in criminal conduct, whatever. Jack's fantasy report. I'm Jack's fantasy report. Neither the Constitution nor applicable regulations or rules allow him to make that public at all. It's the role of the jury, not the prosecutor, to weigh the facts and determine guilt. That hasn't happened here. We've seen this before. Other special counsels have even agreed. For example, special counsel Hur carefully cabined his observations to what some jurors could, might, may well, or at most would likely conclude, is what they said. Might, jurors could, at most, would likely. They didn't come out and say, Trump violated multiple criminal laws. Jack Smith, psychopath, relax. At all points, Hur's focus was on what do jurors think. not on his views or his psychopathy. Likewise, Robert Mueller expressly declined to apply an approach to his report that could result in judgment, and he created his report there. Now, to the extent that Smith possesses any authority to even write anything, and he doesn't, he should have applied the same principles as them, a dispassionate description of relevant facts. We don't need gratuitous commentary like what you're going to put in there. Now, there are many practical and prudent reasons to do this. In 2023, they levied extremely serious, entirely false allegations against Trump. Now, both of those cases are gone. It would be highly improper to allow cases that have been dismissed to create and disseminate yet another document that smears him, even though the cases are gone. He is the subject of an ongoing investigation, by the way, Jack. Smith's plan would be to cannibalize the executive branch. And we've already had congressional hearings where this has been a problem, and we've discussed it. Here, Smith has explained himself and sought unsuccessfully to justify his actions ad nauseum, making us puke our guts out. This has included routinely leaking sensitive details regarding the action of Smith's office. In October 24, it was leaked that Smith planned to pursue 2 cases against Trump for as long as he could. He explained that to them. A similar July report was familiar with Smith's thinking. Another example was this other article. As we learn from time to time, there's private outreach from media sources. Jack Smith is reporting to them. Many gratuitous leaks. He put stuff in his speaking indictments, held a lawful press conference in front of the national media, created an inappropriate 165-page motion for immunity determinations that was accompanied by a nearly 2,000-page appendix. He goes on psycho diatribes against Trump. Even Chutkin said, yeah, it's a little atypical here to have you so demented. Violates procedures and wants protective orders. The guy's nuts. Now, under these circumstances, there is no legitimate need for an additional report to explain anything, okay? He's explained enough, and he's illegitimate. It's all too selective. The draft report goes way beyond explaining policy decisions. It's a list of a psycho with politically motivated grievances who is just trying to rant and rave in his report. The issues of the report that we've just discussed, as we noted, immunity, irreparable damage, election interference, and more, all stacks up, and they must be stopped. Further, preparing and releasing a report would be improper because Smith has relied on numerous legal theories that are completely unprecedented. To name a few, these are cases that lack the opinion that he's relying on them for. There were numerous discovery disputes, and his draft report is selective and inaccurate, completely unfounded and illegitimate. Finally, given the status of Smith and his team, as the inauguration approaches, they cannot use any taxpayer funds. The office has spent tens of millions of dollars, all drawn from indefinite appropriations. But for the period between March 31st, 20 million and another 16 million, 32 million. It's clear, however, the total figure is going to go up dramatically. What all of this lawfare was actually worth to the public is zero, negative millions. We lost a lot of time, money, and the damage that they've done to the Justice Department and the institution of the law is unfathomable. Now, Smith's proposed plan for releasing a report is unlawful. It's undertaken in bad faith. It's contrary to public interest. And so Smith's conduct also raises grave concerns under Article 2. It unlawfully encroaches on executive authority of Trump. He's got a commanding national mandate. The time has come. Stop this weaponization of the justice system. No report should be prepared or released at all. Smith should be removed, including for even suggesting that course of action, given his obvious political motivations and his desire to lawfully undermine the transition. If you elect Merrick to proceed with Smith's plan, we respectfully request you notify us so we can file injunctions. And of course, they've already done that. So that is what Trump sent to Merrick Garland. And that is the motion they submitted to Judge Eileen Cannon. Now, Jack Smith and his team They came back out and they responded. Very short response to all of this. They said, all right, listen, Your Honor, Judge Cannon, Walt and Nada, they filed an emergency motion, and we're just responding. Jack's office, they write, is working to finalize a 2-volume confidential report that we're going to send to Merrick Garland. The Attorney General will decide whether any portion of the report should be released to the Republic. 1 volume pertains to this case in Florida. Now, the Attorney General is not yet determined how to handle the report volume pertaining to this case, about which the parties were conferring at the time of the defendant's filed motion, but the department can commit that the AG will not release that volume to the public, if he does at all, before Friday, January 10th at 10 a.m. And Friday, January 10th is going to be like a Black Friday, man, because they're trying to sentence Trump and trying to publicly smear him on that day. So be cognizant. The special counsel will not transmit that volume to the attorney as to the other volume. Before January 5th, the government will file a response no later than January 7th at 7 p.m. Okay, so that all came in. So reports are dropping, and they're going to be bifurcating it into 2. And let's see what the judge issued in her order. Judge Eileen Cannon issues an order to stay the release of Jack Smith's illegal, illegitimate report. She writes, before the court is an emergency motion filed on J6 by Walt and Carlos, seeks a ruling by January 10th and is appropriately certified to prevent irreparable injury and to stop the imminent release of the public report that's prepared by Jack. This morning, they filed another motion with the Court of Appeals seeking much the same. And so the judge issued the following order. To preserve the status quo as this court awaits resolution by the 11th Circuit, and to prevent irreparable harm between now and then, we now are going to order the following. Pending resolution of what's happening in the 11th Circuit, because there's a parallel issue happening there, all offices, including Attorney General Garland, Jack Smith, their officers, agents, and employees in active concert or participation are temporarily enjoined from releasing, sharing, or transmitting the final report or any drafts of the report outside the DOJ. Otherwise, releasing or conveying or sharing with anyone outside of the DOJ any information or conclusions or drafts. The order remains in effect until 3 days after resolution by the 11th Circuit, unless the 11th Circuit orders otherwise. So no report coming out until the 11th Circuit resolves this. We have to double check to see what the final report includes. Does this include both volumes? Is Jack Smith going to try to distinguish this and say, well, I'll just not release the Florida report, but I'll release the report from the J6 case? Defendants Nada and De Oliveira shall promptly file a notice in this court advising of any activity by the 11th Circuit. The clerk is directed to transmit a copy of this order to the entire DOJ. And they were like just getting ready to press send. Like, this order shall not be construed as a final order done and ordered by Judge Cannon. And so let's go back up and see how she defines the final report. So my question is Jack Smith, and let's see how they defined it here, because there's 2 volumes. Now, is Jack Smith going to try to say that one, like the final report here, issuing a final report under 28 CFR, which Garland is certain to make immediately public. So they're bundling the whole thing up as one report. Jack Smith, I think, is going to be in the process right now of unbundling them, just to say, oh, well, that order only applies to Florida. This is just a Florida order. So I can't talk about the Florida case because I'm illegally appointed in Florida, but I'm lawfully appointed in D.C. Now, he should have stopped working immediately. He should have been off both cases immediately after the Florida case, but he knew he could get away with continuing to prosecute Trump in D.C. because it's D.C. So will he try to distinguish this and then release the J6 report while he withholds the Florida report? We'll see. But a great order from Judge Cannon. So we'll see how quickly the 11th Circuit works. But if this takes longer than 13 days, and it very well may, so if the 11th Circuit takes 7 days, 8 days, Trump comes back in, she comes back, maybe we have an evidentiary hearing. We could get this way past the inauguration, and then the report may not come out. Okay, that's the end game. So Trump's people trying to postpone this until the 20th. She just bought them a bunch of time because it's the right decision. Jack Smith is illegal. Never should have gotten access to any of this evidence. Every single word that he's writing in his report was illegally obtained and paid for with stolen taxpayer money. They should be prosecuted for this, and they should give back their checks. So we'll continue to keep our eye on that one. Major order from Judge Cannon. So that report looks like it is going to be stayed. And we'll see what Jack Smith does. He might just say, well, we'll just release the J6 report because it's outside. It's a separate volume, right? Jack loses again. And Trump got asked about this. As it was happening, we were watching this together on our members only morning stream where we cover other things together live. It's a lot of fun. You should become a member, watchingthewatchers.locals.com or on YouTube. But this morning we were watching this live. This was Trump who got asked a question right as the news broke that Judge Cannon would be issuing a stay on the release of Jack Smith's report.
Thank you.
We have some breaking news. You may not be aware of this, but it looks like Cannon has blocked the DOJ from releasing the Smith's report until further court proceedings. Get your thoughts on that.
That's a big story.
Yeah.
So, if I get it right, the fake witch hunt started by the DOJ having to do with books and records, and Biden had many more, and he wasn't protected by the Presidential Records Act. I was. But all of that fake stuff that took the lives of people, I mean, literally destroyed people. People are destroyed because of what they did. Destroyed. But we got to be president. But Biden did it for 40 years. He did it when he was a senator. That was illegal. And they ruled it was illegal. How about that? They said, it's illegal, but he's unfit to stand trial. So he can stand and be president of the United States, but the prosecutor found that he's unfit for trial. I was going to use that as a major talking point, but I never got to use it because all of a sudden I had a new candidate who was also sort of unfit to stand trial, right? But so what you're saying is that the judge just blocked the, so Cannon was thrown off the case. They dropped their appeal because he had no case. They
Jack
dropped
Smith was
all
thrown
of that, the lawsuits against us. They lost the lawsuit. So this is deranged Jack Smith. So he dropped the lawsuits. He was told to by the DOJ because they had no lawsuit. They lost in court in front of a very strong and a very brilliant judge. They lost in court. And that pertained to other cases in other courts. So he wanted to do a report just before I take office, probably. So he'll do like a 500-page report, and it'll be a fake report, just like the investigation was a fake investigation.
Yep.
And I said, well, wait a minute. This guy was thrown off in disgrace. In disgrace. He's going back to The Hague or wherever they're going to send him. In disgrace.
Gutter.
Because he failed so badly. Because it was a fake case against a political opponent. They thought they were going to use this to beat me. So what you're saying is I'm just hearing that they're not allowed to issue the report. So if they're not allowed to issue the report, that's the way it would be. Because he was thrown off the case in disgrace. Why should he be allowed to write a fake report? It'll only be a fake report.
Right.
That's great news. Good.
Great news. Good. And you can see Trump working that out on the fly. He's like, okay, which one of my 2,000 cases am I going to talk about right now? All right, yeah, the Florida classified documents, Cannon. All right. Assembling it on the fly. And it is good news. That report is getting stalled out. Now, I have a hard time believing that we do not get a copy of that they don't leak this to somebody, that Jack Smith's team or Merrick Garland or somebody on the way out doesn't drop it. But some people are very upset about it. Liz Cheney says as Trump is stopping the release of the imminent final report. She's very unhappy. She must be having a bad day today. She says, while Trump and Barry Loudermilk continue to spread malicious lies about my 1-6 fake select illegally constituted committee, Trump is trying to yet again hide evidence and suppress the truth. The Justice Department obtained evidence and testimony from his advisors, blah, blah, blah. He's doing what despots do, trying to conceal the truth. What happened to all your deleted interviews there, Liz Cheney? Why are we missing so many transcripts? Why is Benny Thompson begging for a pardon because he knows what they've done? The congressional report yesterday, the Dems released a terrible J6 report that's not even worth talking about, destroying Loudermilk's fraudulent allegations. Wrong. So she's upset. She must be really upset that Judge Cannon is not going to allow that report to come out. Liz Cheney having a tough time, and Jack Smith losing again. This is a nice meme of what Trump must be feeling like now that Jack Smith has lost again. You can see Evan Dyer shared this. And so, yet again, Jack Smith's career ends in utter failure. Trump laughing now. Hopefully that report never sees the light of day because it was brought to us by a corrupt, illegitimate, illegal prosecutor and hack. All right. And so, my friends, now let's see what you have to say about all of this. So if you're just joining us, quick recap, lot of legal stuff today. We read through several filings in the New York case. As it stands, Trump's sentencing is still on schedule for this Friday on the 10th. We've also got oral arguments in the Supreme Court on TikTok on the 10th. So we've got, what was the other one we just saw? Sentencing. Oh, and maybe the reports being released on the 10th. So a lot is happening here on the 10th. And so we're going to be here. Thanks for subscribing and joining us as we do. But if you want to rewind, we recapped everything that's happening with the sentencing. As it stands, the Court of Appeals in New York will not be issuing a stay. And so we'll be back here on Friday to see what the heck happens. And I'm sure a lot more is going to be happening between now and then. We might see some petition, like a petition to the U.S. Supreme Court soon. So we talked about that. We went through the proceeding, talked about what happened inside there, read through the very short opinion that came back down from the New York Court of Appeals. And as it stands, we'll be here Friday. Then we read through Trump's motion about why Jack Smith is so illegitimate and illegal and how he should not be permitted to release the final report. He responded saying, we are releasing the report. There will be 2 volumes. Okay, 1 volume pertains to this case. See how what they're doing there? 1 volume is this. The other report relates to another case. So they're going to come out and still try to release the J6 report, even if this one is stayed. But we'll see what Trump files in the other case now. We might see another one of these now filed in Chutkan's court, even though that case has been dismissed as well. But they'll say she's got ancillary jurisdiction. Okay, so then we read through the judge's order. The report cannot be released. The final report, which they're going to say is 2 separate reports, but she's saying it's 1, cannot be released. So we'll see how they try to parse through that one. Trump, it is good news. Very nice to have a victory on another day where we have a very frustrating sentencing, which is continuing to linger out there. But now, my friends, it's time to hear from you and see what you have to say about all of this. Thank you for sending in your very generous donos. Thanks for becoming membos. We had a great members only stream this morning for our YouTube and locals friends. And we have our inauguration watch party, which is coming up on January 20th. And I'm getting excited for this, baby. We ordered, so we got some like pros who are helping out with this one. Our Las Vegas event was great, but I don't really know what I'm doing, as you know. So we now have some very smart people who are helping us assemble a lot of the things, and we're making lists and checking it twice. And we just ordered some stuff. We're setting up a photo booth, and it's going to be great. We got some cool stuff coming. I just signed the numbers on that. So some cool stuff is going to be coming for, pictures. So we're going to be dressing, looking nice and classy. It's going to be classy, but it's going to be a party. It's not going to be too much party because we do want it to be classy. It's the inauguration after all. But we don't want it to be too classy because we're also partying. You know what I mean? So we're having to find that balance. And we got some professional help. So Come and join us. Get your tickets. Linked down below. WatcherLodge.com is the main page. Grab the event ticket. Come join us. January 20th. We're going to be there in person, and it's going to be amazing. So check it out. And I can't wait to see you there. And I'm looking forward to it. It's going to be fun. We're having fun. There's going to be so many American flags. It's going to be great. All right. So now, my friends, it's time to hear from you. And thanks for becoming a member. Thanks for joining our event. And thanks for watching the show and for being here and being amazing. All right, let's see who is joining us on the day and say welcome to some new friends I see who are coming in here. Who do we have? Oh, we got a new baby. Oh, yeah, I saw the Zuckerberg stuff. I did see the Zuckerberg stuff. Hey, what's going on? Donuts clipping for us. Did someone say Taco Tuesday? We're definitely eating tacos tonight. We're making tacos tonight. I got some ground beef at the store. What's up? Dave Hetherington became a shout-out supporter. Thank you, Dave, for upgrading to becoming a shout-out supporter. Really appreciate you supporting us, and especially at that level. Thank you for that. Leslie Bowen. What's up, Leslie Bowen? Thank you for becoming a supporter. We'll see you both on the Membos Only streams tomorrow. I think we'll be tomorrow. We'll be early tomorrow. Membos will be early tomorrow. Rick D, what's up? Hey, Rick D, sharing. Oh, this is a funny one. Meta says fact checkers were the problem. Fact checkers say that's false. It's been amazing. Yeah, Mark Zuckerberg came out today and admitted they've been censoring the hell out of everybody for a long time now. So we're going to stop that now. And we're going to open it up to free speech all of a sudden. What? Hey, what's going on? Uncivil Law says, I am having a really tough time steel manning the denial of the immunity interlocutory appeal. Does this make any legal sense? What am I missing, if anything? So you're trying to, what's up? So first of all, this is Uncivil Law, who's Kurt. He does great content right next door on YouTube and elsewhere. Steel manning the denial of the immunity of interlocutory appeal. So the question is, can you make a good argument for Judge Merchan denying Trump's intermediary appeal, basically the appeal that we're talking about right now? I think you should have a hard time on it. I don't think that there is a good basis for it. And I think that we have even people on opposite political aisles agreeing with this. Jack Smith agreed with this. When the appeal is based on immunity, even Judge Chutkan agreed she couldn't talk on it. I think the best way to steel man it would be to say that it's probably a federalism issue and that the states are just not bound in the same way that the feds are. But Jack Smith tried this explicitly. Trump appealed in an interlocutory fashion. They said you cannot do that right now. And he referenced that Coinbase case, which is a Supreme Court case. And so the Supreme Court case, and even Chutkan came back out and said, crap, you're right, I have to stop. And she stopped. And she is not, like a pro-Trump judge in any way, shape, or form. So I think if she agrees with that, I think Merchan is acting unlawfully. Uncivil says, also, where are you getting these documents? Because I had a real hard time finding the documents for my own streaming. Oh man, that's a great question, Uncivil Law. I got spreadsheets and folders. I'm happy to share anything that you want with you. I'll share whatever I've got with you, but all sorts of various places, like the Trump New York documents, law360.com, I think has a very good tracker. Remembering off the top of my head, they've got a good tracker for the New York case. And then the Florida documents cases are just on Court Listener, courtlistener.com. Just pull up Trump's Florida case there and they're all there. But I do have links and lists and all sorts of stuff. Happy to share it on Civil Law. And if you also want our documents, we also post them at watcherlodge.com. Not that might help you on Civil Law since you're looking for breaking stuff, but we post them there. Watcherlodge.com, all of our PDFs, even stuff that we don't cover, we're posting there. Good to see you on Civil. Says, I would have appreciated legal analysis from either the trial court or the Court of Appeals that explained why the appeal was being denied. I really wish they explained it to me. That's such a good point on Civil Law. It's such a good point. You're right. It would have been useful. They didn't. And we were kind of mocking that. It's too funny. We were mocking that here when Merchan said this, for the most part, that was their analysis. That's what we got. For the most part, it's kind of a repetition. What about all the other stuff? You just going to forget about it? Yeah, you're right on civil law. It's just like, hey man, it is what it is. You guys, we hate Trump. Okay, they could have just come back and it just says, and we hate Trump. He could have just written it right there. It's like, oh, we got it. We got it. You have nothing, no legal arguments. You just say, for the most part, we hate Trump. Got it. And that's the end of it. Thank you on civil law. And my friends, hopefully you're subscribing over there to our friend Kurt on civil law. Great questions, as you can see. And a lot of fun. So thank you for those on civil. Hey, what's going on? We had a baby, Mr. T. We had a baby, Mr. T. The baby thing's a little strange. You know, it's like a Mr. at the front of the title. It's like, hey, Mr. T. We had a baby together. The hell kind of channel is this? We made it. Dems didn't get or eat my baby. Thanks, Rob. Thank you, Mr. T. We did. And we didn't eat it or, put it in one of those DNC vans or anything. Hey, what's up, Michael Stetson? Says, Rob, hey, Kurt on civil law. What's up, Kurt? Ask where you got the docs. Yeah, I get them from a lot of places. A main source is courtlistener.com, and I pay for that. I actually pay, a donation, I think $5 a month or whatever. So I pay that. And then, but I don't think you need to. But that's a really good location. Law 360 is a really good one. There's a couple others that are pretty good. A lot of them from X. I mean, a lot of people post stuff on Document Cloud. It's like a cat and mouse. I'm searching all the time, searching for documents. Like, who's got the documents? Who's got the latest documents? Yeah, Pacer, of course. You could always go on Pacer. You can go on. Pacer's like the official place to get them. I hate using Pacer, and it actually is like slower and crappier than my other sources. So I actually don't use Pacer, even though I'm a lawyer. But the state court cases are the harder ones to track down. A lot of the state courts are difficult to find. And so for those, it just depends. You got to really dig for those. It depends. But Kurt, always happy to share docs. Love to share the docs. Some people are doc hoarders. They're like, they're my documents. I'm not sharing the documents with you. It's like, just relax, okay? They're public filings. Just calm down. They'll give you like a little screenshot, it's like this big. Can I read the whole filing, please? No. We post all our documents at watcherlodge.com. It's free. You can get them. Spuds, what's up? A Northwest Passage would also make Easy California useless as a port state. Oh, this is the Canada. If you want to give Greasy Gruesome the well-deserved middle finger, you could easily rebuild the New York City area as a port, make it red with the help of the MAGA-aligned longshoremen and Teamsters unions, since time and cost of delivery would be shortened and left leaning. Warren Buffett, who owns the Burlington Northern Santa Fe rail, would be jumping up and down. Man, that is a heck of a comment there from Spuds. Thank you, Spuds. Tina Sassy, please hit the like button if you haven't done so yet. Thank you for reminding people to do that, Tina. And please do that. Do it for Tina. You don't have to do it for me. I know you don't care. But do it for Tina, Thank you, Tina. Summerman says the mashing of teeth with this man because of their hate for Trump. They are so mad. They can't help it. They don't even want to write their explanation. They just denied. Court of Appeals, one sentence, denied. Okay, thanks, guys. They have an outcome. They're just making sure they get it. It's already planned. Jason H., how is this not at the Supreme Court? This is a constitutional crisis. What if Merchan was to hold this over his head to get extra funding for New York? Yeah, he could. I mean, that's the thesis, is that if he held, if he didn't sentence him now, then he could hold it in abeyance, arguably, until the end of his term, and then sentence him at the end of his term. And now he's got leverage over the president the entire time. It's lunacy. The Constitution was never organized to support this. It's like dividing by zero. Can't be allowed to happen. Thank you, Jason. Hey, Cyrus, what's up? What are the chances the Supreme Court will step in before January 10th? And when will the appeals ruling be made on Engoron's and Stinky Feet's case? Oh, nipple, Engoron, areola, nipple, Engoron. Good question. We haven't gotten anything back yet from the New York Court of Appeals there. Stinky Feet is Tish, since she takes her shoes off in court and stinks up the whole building. And there's lawyers who do that. And there's other, what is that? What is this funk in this building? And you realize, like, a lot of court buildings have a funk to it. And now we're realizing it's because Tish James, she just is functifying the whole place. So, I don't know. I mean, ordinarily I would say very low But this judge is acting flagrantly in violation of the structure that they have articulated in their case law. So when you do that aggressively and in a politically motivated fashion, the Supreme Court could. I have a hard time believing Trump gets sentenced on Friday, but I have a hard time believing that he doesn't show up for the sentencing. So there's we're kind of stuck here in a way. So the Supreme Court could really solve that. I'm looking forward to seeing what Trump's defense does. I think it's going to get very spicy here. Tomorrow's Wednesday, then Thursday. We got 2 days to resolve this. Contumacious, refusing to obey or respect the law in a way that shows contempt. Contumacious. Turn to your neighbor and say, contumacious. Yes. Make sure that there are no contumacious people in your life. Yeah, there we go. Hey, Leonard, Dems want this Bragg conviction just so they can call Trump a convicted felon, hurting Trump a great deal politically. Is this not cruel and unusual? It is cruel and unusual that these people operate this way. They're trying to wreck America and use our own justice system to do it. But I don't think it would qualify under the 8th Amendment. But it is cruel and unusual. Hey, what's up, Small Cherokee Girl? What's up, Small Cherokee Girl? Thanks for joining us as a supporter. Great to have you. Hey, Jennifer's here. Says, Rob, I found a new channel on YouTube. It's called Pretty Antisocial Podcast. The ladies are great. And they bring the receipts. It sounds amazing, Jennifer. Pretty Antisocial Podcast. I mean, you know, I could get down on that because it sort of reflects my personality. Thank you for that, Jennifer. Hey, Jack is here. It's good to see you, Jack. We got 5 membos coming in. And look at this cat just getting bathed right there. Yes, getting clean. Jack, what's up? Bringing in 5 friends. Thank you, Jack Mack. We got Karen O's coming in. Peter Uri. We got Carol Morrison, JG, and Wrestler Town in the house coming in courtesy of Jack in the house. Good to see you, Jack. Thanks for being here. And we appreciate our new friends. We got this one from Uncle Bozy. Says in other news, President Trump wants to change the name to the Gulf of Mexico to Gulf of America. We were listening to that live this morning, and it was super fun. I was sitting here like, listening, watching the chat, and it came out of nowhere. It's not going to be Gulf of Mexico. It's going to be Gulf of America. Has a pretty nice ring to it. He says, I respectfully disagree. Okay, here we go. It should be renamed the Sea of Liberal Tears because there's going to be so many of them. Also, the Panama Canal should be renamed the USA Canal. And when we free Greenlanders from their current Danish overlords, we should change the name to Freedom Land. I like it, man. I like it. Everything's going to be red, white, and blue all the time. Jennifer says tonight is off-label podcast, fam. Voice of the People is going to tackle the UK grooming incidents. Oh my gosh. Have you seen some of those stories? The most disgusting and horrific things you've seen in a while. Please join us. Off-label podcast. Jennifer will be there. Voice of the People will be there. It's going to be an amazing stream. So click right over there because you don't want to miss it. Stop the China fraud hustle. Stop the China fraud hustle. Became a supporter. Welcome aboard. One old guy's opinion says, Judge Mercan's chickens will be coming home to roost on January 10th. The appeal to the Supreme Court will be a doozy. If not, the Republic is dead, from one old guy's opinions. I think we still got a little bit of life left in us, even if Trump is sentenced. There's a silver lining to it. I mean, it's like they're so upset and mad that they've lost. They're so agitated that they're still willing to double down on what they've done that made them lose. Like they lost because of all this crap. And they're like, we're still going to do it even harder. Okay. You guys are just nuts. All right. Thank you, one old guy. Crash says, Pinocchio's report will surely be leaked to CNN et al. Or the New York Times, etc. Yeah, I think that's, I have a suspicion that that's going to happen. It's like, how can they go through all this and not release the report, even if it is illegal? Who are you going to do? What, do you prosecute them? I hope Trump does. Stop the China fraud hustle. Sending in a nice dono says, if Bragg wants to redeem himself and the SDNY, he should go after the 50 Chinese oligarchs behind the $100 billion China hustle that truly falsified business records, defrauded Americans, and paid the Bidens. Check it out, thechinahustle.com. US. And that's from our friend on Locals as well. So you can check that out. A lot of research there, the ChinaHustle.us. Tony Hay Munkett says, maybe you should wear long sleeve shirts. You're making me feel bad about myself. From Tony Hay Munkett. Well, you just have to go get schmediums, just like I do. You have to take them to a tailor and say, I want you to shrivel this up around the biceps. Nope, smaller. Nope, smaller. She's like, no, what? Are you kidding? Tighten it up. Sir, I can't do it. Tighten it! That's what happens. Hey, stop the China fraud. Rob, can you riff a little on Biden, Rico, and my post based on what you know and have read? Also, what the Oversight Committee found? We can't do that right now, stop the China fraud hustle. But I appreciate the work that you're doing on the China fraud. And we appreciate you continuing to raise attention to it. But you've done a lot of work, and so there's a lot to riff on. I'd rather send people to your place at the ChinaHustle.us so they can riff for themselves. Pamela Blunk. What's up, Pamela Blunk? Thank you for becoming a supporter. Grab that members only stream from this morning. Same to you, Jason Finch, aka Dr. Salty's in the house. What's up, Dr. Salty? Thank you for becoming a supporter. We'll see you back here tomorrow. Membos, we're going live 1 hour earlier tomorrow, and it'll be probably a pretty quick stream. I got a boot camp kind of all day tomorrow that I'm doing. So we'll still have a show tomorrow, but from like 9 to 3, I've got this boot camp. So that's what I'll be doing. So we'll do a Membo stream right before, and then we'll jump into that, and then we'll do our stream. So Pamela and Jason, we'll see you tomorrow, 8 a.m. Arizona, 10 a.m. Eastern for the Membo stream. Norman Lee Smith Music. Hey, what's up, Norman Lee Smith? Says J6 will forever be known as Fake News Election Day. Fake News Election Day. Fake News Day. Yeah, I think that's a good idea when our government tried to propagandize us. Hey, Pam Ragland says, I think you know this, but Pacer has all federal filings not sealed by the docket. Yeah, and honestly, Court Listener generally does too. Sometimes you won't find something that's been published on Court Listener, but it's pretty good. And cases of public interest are usually on Court Listener, and it's got notes, and you can follow cases. It's much better. Thank you, Pam. Great tip. Liz. Hey, thank you, Liz. This is for my virtual ticket towards your watch party. I'm in Ohio. I'll be watching with you from the Buckeye State. Liz, thanks for that. So we're also talking about creating a digital ticket that might have some like behind the scenes stuff for the watch party. I know many people can't travel to Arizona for a one-day event for the watch party. So we're planning on live streaming it. Definitely like a full live stream, I would say, just for Trump's swearing in and inaugural speech. But then we are thinking about a digital ticket if you want to hang out and kind of be a part of the after party or whatever we're going to call that there. Because we have a community that we're building at watcherlodge.com. And so, Liz, if you want to be a part of all that, send me an email. Send me an email to robert@spotlightlawyer.com. And I can add you onto the list. Thank you for that. I appreciate it. Either way, thanks for donating to us, Liz. And thanks for contributing. But official tickets are at watcherlodge.com, and we have the links in the description below. But Liz, thank you for that. I cannot wait for the inauguration. It's going to be so fun. I had so many ideas last night. We had a meeting on it yesterday, and I said to the two, what if we do this? Is this crazy? She said, no, it's not crazy. Do it. And I said, okay, I'm doing it. And I did it. It was great. So check it out. All right, what's up? Debbie Witt. Can Mercan get away with this? 13 months as a membo. Thank you, Debbie. Well, he's getting away with it right now. He's in New York, so the New York authorities are in on it. The Court of Appeals are down for it. Everybody's having a good time. They don't care what they're doing. So he's getting away with it so far. We'll see what happens in the next 4 years, though. Jack Mack, what's the Gulf of America? Well, it's the current Gulf of Mexico. I love it. When I was in Iraq, there were two palaces next to each other. The huge one was called Victory Over America. The little tiny one next to it was called Victory Over Iran. Amusing. That is interesting. From Jack Mack. That is interesting. Well, we're going to rename the Gulf of Mexico into the Gulf of America. I don't know why it's the Gulf of Mexico anyways. We've got a bunch of states that envelop it, including Florida, which comes around and like gives it a little hug. It's like America's giving the whole body of water a hug. from Texas to Florida. It's ours. We envelop it. So it's Gulf of America, henceforth. One old guy's opinions says SCOTUS must deal with the Mercan case because of the legal precedent. What kind of case law will it set for the future of the republic? You're right about it. I mean, this judge is flagrantly violating the Supreme Court. Even Judge Chutkan had to buckle and bend. This judge doesn't care. Hey, Melanie, thank you for this, Melanie. Love they channel. Thank you. Is that like a love they I channel? Is that like French or something? It's like Thai food kind of a thing. Is it ethnic? Thank you, Melanie. I'm just joking. Thank you for the very nice dono. I appreciate it. Hey, we got a new baby in the house. Tina Sassy. Missed you live over Christmas. We missed you, Tina. Happy New Year, all. Thank you, Tina, for being here for 9 months. That's full term. Full baby in the house. Happy New Year to you, Tina, and to everybody. It's been a fun and exciting start to the new year. No doubt about that. Let's say hello to our friends on X before we wrap it up and go on over to Locals for our members only after party and see what's happening over there. We had some comments today from Fred. Fred says, my earlier super chat, was it? My earlier super chat, Fred, are you okay? Man, I hope you're okay. His super chat about the book, The Blood of Abraham, was written by Jimmy Carter. He was talking super chat. It's just a really funny typo. It's one of the most informative books on the Middle East and Israel. Well, that whole conflict over there really is a super chat, isn't it? It's been a super chat my whole life, so the book sounds appropriate. And it was written by Jimmy Carter, who had a super chatty presidency. So sounds like a great book. Thank you for the endorsement of the book there, Fred. I know it was a genuine endorsement, and I just totally wrecked, your endorsement. Thanks for the correction and the super chat. B. Torn says, if justice delayed is justice denied, then justice ignored is justice condoned. James Pepper's over there. We got some good comments over there on X. Got some good comments. Esands. Hey, Rob. I can't share them on the screen, but Esands. Hey, Rob, your number one viewer from Ireland again. Never miss a show. Thank you, Esands. And shout out to our friends in Ireland. It's funny how these judges, prosecutors, and fake prosecutors reckon they have more immunity than a president. A swift kick in a non-violent way might help them see some sense. I hope it's delivered soon. Yeah, the proverbial legal backhand. The proverbial backhand. It's all we want. We don't condone any political violence here at all. Never have. Never will. But my friends, it has been a beautiful stream. I got to get it together, acting like I'm in middle school again. Melanie. It's a typo. It's a typo. Hey, Crash says, during the Monroe administration, they referred to the Caribbean and the Gulf of Mexico as the American bathtub. Is that right? It's because we hug it, right? It's because we hug it so lovingly. Thank you, Melanie, for calling out the typo. It was a good one. It was a fun typo. Super chats. Man, sounds rough. MJ Powell, look what's happening here, my friends. Oh my goodness. MJ, super generous. Thank you, MJ, for bringing in 50 new members who we'll see tomorrow morning for our members only morning stream. Amazing. Let's welcome them in. The cat is coming in. Rose Bennett. What's up, Henry G? Pamela Nizlak. We got Frank Williams, Sean Price, Tsunami. AF5WO Field Boss. CV Grady, what's up, Calbo Dave? Jimmy Baker's here, 655. George A. from Southeast Michigan. What's up, George? We got Kitchen, Mortician, Nightman's wife. Rodney's coming in. William Meyer, I. Kimbo's here. Cat McC. What's up, V? Holy F is here. We got Chillaxin, welcome. Zach on Glass, Stephanie A. Brian Howell, Nutter's here. DSH. Hangman is here. We got Renee, Lexi, Mike Sue, Tyler Harden, Netcat Media, Karen Bush, Aussie Nan, Will Polera. We got Charles Schwartz, Chair Rocking, Tara Eggers. We have more coming in. Black Horse Cavalry, Annie Palmer, William Shawley, Uncommonly Common, Keyhole is here. Smokestack Lightning and more, like Bao Lowe and Joel Rays and Chris LaForest. Gifted membos in the house, courtesy of MJ Powell. MJ Powell, thank you for that. 50 new friends. Welcome aboard. Courtesy of MJ. MJ is also a Spotlight supporter in the house. MJ, thank you so much for what you do to keep us afloat here. And welcome aboard. Just Rhonda is welcoming everyone in. Lisa's here, welcoming folks in. Pamela says, hey, Rob, just wondering, with Trump suing the judge, can't that put a stay on it? So I heard that Trump was announcing that he was suing the courts, but I heard him say that today at his press conference, that he was suing for the raid of his home. I don't think I've seen a lawsuit filed against Judge Merchan yet, but that is another option. Sue for some sort of an injunction at a federal level, and then have a federal judge issue an injunction. And then if that is denied, take that up to the appeals court, to the Supreme Court. But that we're like running out of time. Sentencing is on Friday. So all of those things might be happening simultaneously tomorrow. Sue Merchan, Sue Bragg for an injunction in federal court. Also simultaneously submit a petition for a writ of cert up there. But I don't think I've seen anything like that today. But Trump did say that he was going to sue the U.S. government today during his press conference. And I'm not saying it didn't happen. I just may have missed it. I was just focused on these other two locations. That's what Uncivil said. That's what I said. Writ of prohibition and hope for the best. Yeah, so I think it's still probably a long shot. He'll sue what? In the Southern District of New York, which is not a real favorable jurisdiction for him either. That's where he had the E. Jean Carroll case. And yeah, that was that one. So tough road ahead. We're going to see what his attorneys do. And of course, we're going to be here tomorrow to get into it. And so thank you, my friends, for joining us. Thanks for sending in all those amazing donos. Welcome new membos. We'll see you tomorrow. Membos, 8 a.m. Arizona tomorrow, 10 a.m. Eastern. We'll say our hellos and our good mornings, and then we'll be back for the full stream. And so before we wrap it up, my friends, I want to thank our amazing mods and meme smiths who help mod the fort down for us and keep things nice and orderly. K Bean in the house, Donut, Carrie B playing hooky. We got Dog Digger and Janik on the rumbles helping out, mod the fort down for us, keeping things so beautiful and so nice and orderly. We also got our tickets to the inauguration watch party in Arizona. If you're going to come out to Arizona or in Arizona or know anybody in Arizona, we're hanging out on Inauguration Day. Live and in person, baby. It's going to be a ton of fun. We're going to have brunch. We're going to have people and video screens and photo booths. It's going to be amazing. So grab your tickets. They're $100. It includes everything you need. WatcherLodge.com. Click the event, grab a ticket, and we'll see you there. It's going to be fun. We also want to say thank you to you for being here on the day. Of course, we're going to pause here for a few short hours, but we're coming back here tomorrow. It's going to be Wednesday. We're going to have more business to attend to. And in order to do it appropriately, we're going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.